Have you ever heard of this trial dilemma? You've spent years litigating your case goes all the way to trial, and now there's been no offer whatsoever. As the jury is deliberating, the defense comes to your attorney and says, listen, we'd like to try and settle this case before the jury comes back with their verdict. What do you do in that instance? Would you like to know the answer? Come join me for a walk near the marina as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. That's not an easy question to answer, and I'll tell you why. You believe that someone was careless and caused you significant harm and injury. The defense, throughout the entire course of your litigation, has refused to accept responsibility for anything that occurred. They have refused to accept responsibility that they were careless. They have refused to accept responsibility that anything they did caused you any type of harm or injury. And they also refuse to accept the fact that you suffered significant harm and injury. In that instance, now you have resolved yourself to the fact that your case is going to go to trial. You have resolved yourself to the fact that you are never going to settle your case, that the only way you could possibly get any type of compensation for all the harms and damages and losses that you incurred is to go to a jury and to have the jury ultimately decide a case, hopefully, in your favor. That is what you have resolved yourself. Why? Because your attorney has told you repeatedly that the defense has no intention whatsoever to ever offer you a dime to settle your case. They don't believe they did anything wrong, and as a result, they will never settle this case. Okay, so now that's the mindset you have developed during the entire 2 or 3 years of litigation that you have fought this case and continued to fight this case. You will now go to trial, and you are on trial for 3 solid weeks. And it is an up and down roller coaster, an emotional roller coaster during the entire time you are at trial. There are days when you are elated and you feel fantastic because you and your witnesses have done remarkably well and your attorney has gone ahead and destroyed every single witness that the defense has put up there. There are other days where you feel horrible. Why? Because things definitely did not go your way. Witnesses did not go your way. The defense lawyer tore apart your witnesses. And now it's an emotional roller coaster. It is frustrating. It is emotionally exhausting. And you are tired. You are exhausted. But now you have come to the end of your trial. The attorneys have now made summations. They've made closing arguments. The judge has now given the jury the legal instructions on what they need to consider as they determine whether or not the doctor, in your case, violated the basic standards of medical care, whether he was negligent, and if so, whether his negligence was a cause of your injuries, and if so, how much money they are to give you for all of the harms and damages you suffered because of this person's carelessness. So now you are almost at the finish line. The judge gives the jury these legal instructions with specific questions that they have to answer. And now he tells them, go out and deliberate, and don't come back until you are done with your verdict. In that instance, now you have resolved yourself that this jury is going to sit and deliberate all of the questions that came up, and they're going to evaluate all of the medical records. They're going to evaluate all the testimony and all the proof that has been put forward into the case. So now you expect it's going to be quite a while before the jury comes back with their answer. While you are sitting outside the courtroom, sitting and waiting, there is nothing to do in the meantime. You can't really go off and come back a few hours later because you don't know when the jury is going to come back with their verdict. So you are nearby. You are pacing the hallway. You are talking to your attorney. You're on your phone. You're trying to keep yourself busy. Your attorney is trying to do the same exact thing. The opposing lawyer is trying to do the same exact thing. The people whom you have sued are also doing the same thing. And you're waiting, and there's a lot of anxiety, and no one knows exactly what's going to happen. Your attorney calls you over and pulls you to the side of the hallway and says, listen, I just want to let you know, the defense attorney has approached me for the very first time. And now they said, listen, we'd like to try and negotiate and settle this case before the jury comes back at any moment. And you say, what are you talking about? They've told me from day one that they would never settle this case. So why is it that now, for the very first time after 3 years of litigation, they now come and tell you, listen, we'd like to try and settle this case? And you know what your attorney says? He says because they're scared, because of the unknown, because they don't know what's going to happen. And they want to try and limit the risk that a jury is not only going to come back with a decision in your favor, but they think, or at least there's a possibility that they want to limit that risk, that the jury comes back with a verdict far in excess of what we actually believe the case to be worth. In that instance now, that means that they are going to have to ask the judge to reduce the verdict or throw out the verdict. And if that doesn't work, then they will have to try and appeal and try and establish that there were errors of law that were made by the trial judge, and now ask the appellate court, the higher court, to throw out the verdict or to reduce the verdict or to send the case back down for a brand new trial and start the case all over again. Those are all possibilities. And now it seems that they're getting worried. They're getting worried because now it's been hours since the case was given to them, and each side expected that a decision would be relatively quick because the evidence was straightforward, the proof was straightforward, and neither side can figure out what's taking so long. Why is the jury hung up, and why can't they come to a quick decision about whether or not this doctor did something improper, and whether or not that improper treatment caused your injuries, or whether or not they're trying to decide or they can't figure out how much to give you. Now, all of those things are all possible. But now you are faced with having to make the decision about, number one, whether to go ahead and enter into settlement discussions. And now you're under the gun. There is a time limit. The clock is ticking. Why? Because at any moment, the jury could come back with a verdict. And if they come back with a verdict in the middle of you trying to settle or negotiate your case, all bets are off. Any settlement discussions that happen before the jury comes back with their verdict, once they come in with their verdict, in all likelihood, neither side is going to want to continue negotiating. They're going to want to listen and hear what the jury had to say. And believe it or not, you may have the best case in the world. And you may have had the best experts. And you may feel very strongly that the jury is only going to side with you on every single point. However, there is also the great possibility that the jury will disagree with every single thing that you've done. That the jury will disagree with every single point and come back and not give you anything and tell you that the doctor did absolutely nothing wrong. In that instance, all of your efforts, all of your attorney's efforts are for absolutely nothing. So you run the risk that you will walk out of court without a single dime and without getting any vindication that the doctor who treated you was in fact careless and caused you harm and injury. That is a possibility. So now the defense is scrambling to try and minimize and reduce the risk of the jury coming back with a substantial verdict in your favor. Your attorney has to talk to you quickly about the risks of accepting any type of offer, the risks of making a counter offer, and the risks of rejecting an offer. There are risks to each one of those things. If you enter into settlement discussions, can you go ahead and settle this case before the jury comes back? The answer is you could. Do you know what's behind door number one? Meaning, do you know what the jury is going to do? The answer is no, you don't. Your attorney doesn't. The defense attorney doesn't know. The judge doesn't know. The only people that know what the jury is going to do is the jury. So you don't know what's behind door number one. And now you have to decide whether to take what's behind door number two, which is the defense's offer. And if you think it's an attractive offer and your attorney agrees it's an attractive offer, now you have to consider whether or not to counter offer and to try and get some additional money beyond what they have already offered. If they're scared about getting such a large verdict, now they've offered X number of dollars, maybe they'd still be worried and they're willing to go up to X plus Y dollars. So let's see if we can pressure them into coming up with the maximum number possible. And that may be a good strategy, considering that the jury is going to come back with a verdict any moment. So in that instance, there have been cases where the parties have settled their case as the jury is deliberating. There have also been instances where the parties to the lawsuit have been in the process in the middle of negotiating. The jury comes back and they tell the judge, Your Honor, we are almost at the point of settling this case. Before you bring the jury back in, give us 5 more minutes to see if we can wrap this up without the need to bring the jury in for a verdict. Now, wouldn't it be nice if the judge went into the jury room, asked them what their verdict was, then came out and now try to encourage negotiations to occur. Well, that would be nice, it would be wonderful, but there would be many, many problems associated with that, and it's not going to happen. A judge is not going to do that once he has that information. Now he already knows what the jury outcome is, and now to try and negotiate a case that he knows maybe the jury comes back with a defense verdict, that would not be proper. So in that instance, what's going to happen? The judge is not going to interfere. In all likelihood, he will give the parties a few more minutes to go ahead and see if they can resolve the case on their own. If not, he's going to bring the jury in and ask the jury to read their verdict. So why do I share this quick information with you? I share it with you because this happens from time to time. And now, despite the fact that the defense has refused to negotiate and offer a single dime throughout the lawsuit, now, as the jury is trying to come up with a verdict, now each side gets worried. Maybe it's enough to get the defense to come up and offer a substantial settlement. And now, if you're inclined to accept it, great, the case is done and over. And in the back of your head, you're wondering, what was the jury going to do? And your attorney may actually be able to learn that information after the jury is discharged. And then once you've settled your case and your attorney learns the details of what the jury was going to do, hopefully he'll share that information with you, and you're either going to kick yourself for saying, hey, I should have let the jury come back with a verdict. They would have given me 10 times more than what we settled for. Or it could have been just as bad, where they could have turned around and said, no, you lose and get nothing. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.